On behalf of the Harvard Law School Library, I'd like to welcome you to today's book talk in celebration of the recent publication of Sovereignty and the New Executive Authority, published by Oxford University Press in November of 2018. Joining us today for today's book talk, we have one of the book's editors. We have Claire Finkelstein, who is the Algernon Biddle Professor of Law and Professor of Philosophy at the University of Pennsylvania Law School. Professor Finkelstein is also the director at the Center for Ethics and the Rule of Law. Joining Professor Finkelstein are two of our local faculty. We have Charles Freed, who is the beneficial professor of law and has been teaching at Harvard Law School since 1961. He was Solicitor General of the United States from 1985 to 89 and was an Associate Justice of the Supreme Judicial Court of Massachusetts from 1995 to 1999. He contributed a chapter to Sovereignty and the New Executive Authority titled Defining and Constraining the Sovereign, the Most Difficult of All Tasks, okay, and I'm sure he'll speak to that. We also have Adrian Gurmule, who is the Ralph S. Tyler Jr. Professor of Constitutional Law at Harvard Law School. Before we begin, I have just a few announcements. First, the Law School Coop is right outside the door with books for sale at a 10% discount today, so please stop by on your way out. And I'd also like to thank the Dean's Office for sponsoring today's lunch. And finally, I just want to remind you that today's book talk is being recorded and will be available to you and your friends who haven't been able to join us today on the Law School's YouTube channel within about a week after today's talk. Thank you, and now I will turn the microphone over to our speakers.
Thank you so much, June, and thanks so much to Charles and Adrian as well for agreeing to participate in today's discussion, and to all of you. This volume came about because of a conference that we held at the Center for Ethics and the Rule of Law at the University of Pennsylvania Law School, which I direct, a whole 3 years ago. And it takes a while for these volumes to come out, and as so often when there is delay on this sort of thing, you think, well, by the time it comes out, it won't be relevant anymore. Well, we sort of lucked out in that regard, because the topic of sovereignty and executive authority is more relevant than ever. But let me just say that if, as I'll be discussing in the talk, if you worry that there is an anti-Trump bias in these remarks, please remember that the entire project came about when Obama was president. So, and I'll be making some comments about that. So in slightly over 2 years since Donald Trump took office, there's been much discussion about what we would commonly refer to as the rule of law, a phrase whose meaning may elude the vast majority of the American population. And I have to say that when I was a law student at Yale, I went through my time there sort of scratching my head over that phrase, wondering exactly what does it mean. Properly conceived, that term has at least two different aspects, I would say. First is the idea that we live in a society in which power is exercised according to laws. And second of all, that elected and appointed government officials are not themselves above the law, but are subject to the law. Dismayingly, in the past 2 years, many believe that the Trump administration is flunking both these tests. Many actions of significance that Donald Trump has taken also appear to be extra-legal, things that have no precedent in law, which have left many people puzzled and confused. Second, the current occupant of the White House makes noises to the effect that he regards himself as above the law, though it's not actually clear how much he's done to violate that law or to carry out that conception. But he seems to suggest that he accepts no constraints on himself or on his office of any sort. He appears to display, in short, what Arthur Schlesinger Jr. called an imperial conception of the presidency. And this was, of course, this book written at the time of the Vietnam War, so these discussions about the imperial presidency have been going on for quite a while. This is not the beginning of it. It has, however, reached a kind of fever pitch in the last 2 years. And as I suggest, it may be partly more because of the rhetoric of this administration than what it has actually done, though there are suggestions that some of the things that the president has done, in particular the recent declaration of a state of emergency, may be an abuse of executive power. It would bear note, however, that there have been many such claims of abuse of executive power before. There have been periods in the history of this country when one branch or another has suddenly seemed to dominate the other two. Excuse me. Alexander Biddle wrote sarcastically about the least dangerous branch to signal his concern about a runaway federal judiciary that he believed had slipped its harness and was now usurping the power of the other two branches. And concerns about presidential overreach have been heard with some frequency, at least since President Lincoln suspended the writ of habeas corpus during the Civil War. It is indeed typical that complaints about expanding executive authority occur in times of war, since that's when presidents, prime ministers, kings, and emperors are at their most dictatorial, and when other countervailing sources of power are least willing to confront and constrain executive authority. It's interesting that when Lincoln suspended the writ of habeas corpus, and in fact, the Supreme Court declared it unlawful, nothing happened after that. Nothing happened to Lincoln, and nothing happened to follow up on the court's declaration. So, in fact, there have been declarations to the effect at times that presidents have overstepped their bounds, but little action following up on those declarations. One such action, however, did occur at the time when, of the Korean War, when Truman tried to take over the steel mills, famously. There was a strike that was about to occur, and he was concerned there would not be available steel for the war effort, and so he suspended the control of the steel mills and tried to take them over. Famously, the Supreme Court declared that unlawful, and he was unable to do that. But typically, this is what happens during time of war. The executive branch, the president in particular, comes to exercise greater authority, seems to have greater mandate for doing so, and usually, the steel mill case being an exception, there is little pushback to presidential authority at such moments. Since 9/11, the pace of expansion of executive authority has increased. And at the same time, the other two branches of the federal government have become more passive and more deferential to the executive branch. It is the usual strengthening of executive authority during times of war, but with the added kicker that this was the longest, largest, and least anticipated attack on US mainland and in our history, and the longest war following such an attack. In our semi-traumatized state, we were searching for protection and revenge for many years thereafter, and indeed now still continue on the original authorization for the use of military force that Congress passed right after 9/11, and our remaining troops in Syria are still operating on that original mandate. Now, one of the things that the book tries to do is to put these debates about presidential authority into the context of the original concept of sovereignty as it emerged many, many years ago, over 400 years ago at least, though there were, of course, rulers and discussions about the concept of government before that. But I would trace the modern beginnings of the concept of sovereignty to the writings of Thomas Hobbes. In the introduction to Leviathan, Hobbes sets out his conception of the sovereign as the soul of a nation that animates the commonwealth, much as the soul of an individual animates a man. He says, By art is created that great leviathan called a commonwealth or state, or in Latin, civitas, which is but an artificial man through the greater stature and strength than the natural, for whose protection and defense it was intended, and in which the sovereignty is an artificial soul as giving life and motion to the whole body. Hobbes famously compares the commonwealth to an artificial person, artificial because the commonwealth is made by artifice, not by nature. In this, there are the seeds, I would argue, of democracy, as the artificial person is authorized to act for the people because they perceive themselves as better off under his reign. However, Hobbes' sovereign is definitely above the law, not subject to it. It seemed for Hobbes an impossibility that the lawmaker could himself be under the law or subject to the law. Interestingly, though, Hobbes' conception was in a way democratic in that he saw the sovereign as authorized by the people, so that the sovereign, though he is not constrained by that authorization, once authorized, acts on behalf of the people. And indeed, in this image, you see the sovereign's body is literally made up of people, as an artificial man would be composed of many people. So one question, the question that we've been grappling with, particularly vocally in the last 2 years, is the president subject to the law, or is he in some ways above the law, was very much the question that Hobbes and his successors struggled with. One of the most influential jurisprudents to have commented on this topic is H.L.A. Hart. H.L.A. Hart, in his famous book, Concept of Law, wrote about a distinction between primary and secondary rules. The primary rules are rules of conduct. The typical example is rules of the criminal law, where you are told what you may do and what you may not do, so rules that pertain directly to behavior. And the secondary rules are rules about other rules, rules that tell you when you can change a rule, or what to do when two rules conflict. Those are the rules by which the office holders govern rightfully under the law. So the rules that set out the Electoral College, how someone becomes president, how someone becomes a senator, all those are, for Hart, secondary rules. The most significant way, then, in which the president, the executive branch, and everyone who holds office in our system is subject to the law is, to put it in Hart's term, that they are subject to secondary rules. They hold their power not because of the person they are, but because they rightfully occupy an office that's defined and identified by rules. Okay. So in recent times, I think it's important to bear in mind that we have not seen a change in the basic fact that office holders hold their offices by dint of secondary rules. They retain their power by those rules, and as of yet, there doesn't seem to be any particular pushback to the idea that secondary rules ought to govern how one holds power. What we've seen, therefore, is a stretching of the rules, a bending of the rules, and, as I say, since 9/11, a steady accumulation of power on the part of the executive branch, particularly the presidency, and a weakening of the degree to which the other branches are willing to stand up and push back. Under the Bush administration, the introduction and defense of torture and cruel and degrading treatment in the interrogation of terror suspects was arguably one of the ways in which there was an expansion of executive power, a push at the boundaries of executive power, and where rules that we understand for how executive power functions were weakened and and relaxed, and where courts were generally unwilling to push back at the executive branch, and Congress was largely silent as well. Under the Obama administration, a similar logic, indeed the very same logic that the Bush administration used, namely the device of unlawful combatancy, formed the basis for the targeted killing program. And there were as many arguments with regard to abuse of power on Obama's part as there were with regard to the Bush administration. And finally, the Trump administration, with measures designed to halt foreign immigration and refugees, has come largely under fire for supposedly violating rule of law values in that area. Okay. Now, what should the relationship be then to the president and the concept of the rule of law? To what extent is the president above the law? That's one question. A second question is, who is going to police the boundaries of the president's relationship to the law? I'm going to skip over a slide here and say that if you see the president as the inheritor of a monarchy, you will have very different views about this than if you see a president as the inheritor of the concept of popular sovereignty in a strongly democratic tradition. My former colleague, John Yoo, who holds very strong views about the right of the commander-in-chief to exercise fairly unfettered authority under Article 2 of the Constitution, once famously argued, quote, that Cato correctly concluded that in the realm of practical politics, the president's authority under the Constitution did not differ in important measures from that of the king. And he has arguments with which I think Adrian Vermeule may agree, though I don't know that he will discuss that here, that this is the right way to think about presidential authority. Interestingly, even Hobbes, who was a great defender of monarchical authority, did not see the monarch as having the unfettered ability that the king did in the conception that John Yoo puts out, because he wrote extensively about the right of people to rebel when the king is no longer able to protect them or no longer has their deepest interests at heart. I think that, and I'm going to end here, though I had other points to discuss, but I see we're running out of time, that Hobbes, in fact, would have been very sympathetic to the modern device of impeachment, and might even have been sympathetic to the concept that a president could be indicted, though I will say that's extremely difficult in our system. The discussions that have taken place around this, having to do with the Department of Justice memo that say that a sitting president cannot be indicted, I think failed to grapple with the reality of what it would mean to indict a sitting president. I had hoped to have some discussion about that, and maybe we can do that in the question period. Thank you.
Well, thank you to the library folks for putting this together, and to Claire for her talk. So the title of my, I want to apologize in advance for having to dash out early. I have a class that starts right at 1, so I can't stay for the whole time. So the book raises a number of issues, and I can't hope in 10 or 12 minutes to do more than make one substantial point. And the hope of this point is to kill the fun as much as possible. And the suggestion is going to be that there's been no significant issue about the relationship between executive power and the rule of law, at least since 9/11. So talk about the rule of law is largely irrelevant in our current conditions. Everything that has occurred, every controversy surrounding presidential or executive authority, has been entirely internal to the ordinary practice of legalism and has involved applications of ordinary legal standards and arguments that are theoretically banal, however great their practical importance, with one arguable exception I'll mention at the end. Typically, when people think they're raising issues about the rule of law, they're actually raising issues about the sweeping delegations of statutory authority to the executive, especially in matters of national security and immigration that have occurred during and after World War II and through the 20th century and after 9/11. So these complaints that are really about delegation can be circuitously phrased as complaints about some enhanced or thick version of the rule of law, which is said to fold into itself human rights, liberty, and all other good things. But delegation does remain the central issue, and very little is gained by talking about the rule of law in this context. A lot of confusion is introduced about the real sources of executive authority. Let me begin with a legal analogy. It's a fairly obscure case from 1994 called Dalton versus Spectre, which involved the Defense Base Closure and Realignment Act. The suit tried to enjoin the Secretary of Defense from carrying out a presidential order under the act to close the Philadelphia Naval Shipyard. And the court, through Chief Justice Rehnquist, held that the claims were not reviewable. The president's order couldn't be reviewed under the APA for conformity to statute, because the court had previously held in Franklin versus Massachusetts that the president didn't count as an agency under the APA. Now, to circumvent this barrier, the litigants attempted an ingenious gambit. They said that any claim that the president has exceeded statutory authority is always and necessarily a constitutional claim, which is reviewable notwithstanding Franklin. So the theory ran that if the president lacks statutory authority to do X, and supposing there's no independent grant of constitutional authority to do X, then under Youngstown Sheet and Tube Co. versus Sawyer, the president would violate the Constitution by doing X. The court dismissed this theory out of hand, and the Chief Justice observed that this gambit would eviscerate a distinction we apply all the time in law, which is the distinction between executive action that is unconstitutional and executive action that, purporting to rest on statutory authority, merely turns out to be ultra vires in excess of that authority, as in every ordinary administrative law case. And the court added that the rule of law is just as fully vindicated when the courts hold that executive action is committed to executive discretion by the law, as it is when courts review and overturn executive action. So Dalton v. Spectre captures by analogy what I think is a crucial point about executive power and the rule of law. When the executive appeals to ordinary positive legal authority, such as a statute, there's no issue about the rule of law, no interesting issue of grand theory, even if the executive's appeal is mistaken in our judgment or in the judgment of the courts, and even if the executive has acted arbitrarily or abused its legal discretion. After all, we don't think that the rule of law is implicated in any unusual or illuminating sense whenever the D.C. Circuit decides that an administrative agency has exceeded the bounds of its statutory authority by offering an unreasonable reading of the law, or even if the agency has acted arbitrarily and capriciously, as happens approximately once a week. The talk about the rule of law in that context just sort of seems unnecessary. We just do administrative law from within. Let me turn now to the presidency, where the same points apply mutatis mutandis, as I've argued and as Jack Goldsmith argued independently. The beginning of wisdom here, and I'm going to use my categories, not Goldsmith's, is to make a distinction between what Commonwealth lawyers call extraordinary prerogative and ordinary prerogative. So ordinary prerogative is internal to the legal order. It includes the prerogative powers of the Crown that are themselves granted, at least arguably, by ordinary legal sources and authorities, common law or statute, or in our system, granted to the President by the written Constitution. Extraordinary prerogative arises when the executive genuinely acts outside the legal order or contrary to it, usually in the name of saving the legal order in some higher sense. Note that ordinary prerogative includes both cases in so-called Category 1 of Justice Jackson's Youngstown concurrence, where the executive acts under express statutory delegation, and Category 3 cases where the executive claims that positive constitutional grants of authority to the president trump contrary statutes. My thesis is that approximately all assertions of presidential and executive authority since 9/11 have involved ordinary prerogative, usually on the basis of statute, so that's Category 1, very rarely on the basis of constitutional authority said to override statutes, Category 3, the main recent example being the bipartisan position of Presidents Bush and Obama that led to the second Jerusalem passport case. But these arguments are always within the enacted legal order at whatever level. Now, our history has seen genuine assertions of extraordinary prerogative on the part of presidents. Examples are some but not all of Lincoln's actions at the beginning of the Civil War, or FDR's rather chilling warning to the courts that he would not listen to judicial judgments in favor of the Nazi saboteurs in the litigation that led up to ex parte curing. Approximately since World War II, however, and certainly after 9/11, there's been almost no need for such things, and it's very hard to find examples. And in large part, that's because Congress has delegated such sweeping powers to the executive under statutes both broad and vague or ambiguous. And the courts have upheld those delegations even when the delegation itself has involved so-called emergency powers, as when the court upheld the Emergency Price Control Act of 1942 in Yakus versus United States. Now, one might or might not find this delegation objectionable. I do not. But that is the issue to discuss, and talk of the rule of law is largely odious or at worst misleading in this context. I want to just give one current example, one that Claire mentioned, and I think it's produced an outsized share of hysteria in recent months. This is the National Emergencies Act and President Trump's associated proclamations. It seems counterintuitive to many people, but it is nonetheless true that there's literally nothing interesting in this episode about the rule of law, at least in any sense that's not also implicated when EPA has to meet a claim that it has exceeded its authority under the Toxic Substances Control Act. So legally, these two cases are on a par, and the second sort of case is, of course, the ordinary stuff of administrative law litigation. First of all, the administration points to one major source of statutory authority that has nothing to do with emergencies at all. It's a statute signed into law by President Obama on December 23, 2016. It's codified at 10 U.S.C. 284, and it authorizes the Secretary of Defense to support the, quote, construction of roads and fences and installation of lighting to block drug smuggling corridors across international boundaries of the United States. Now, the administration might be right or might be wrong about whether this express statutory delegation does or does not cover what it proposes to do. But so might EPA in toxic substances litigation. The talk of the rule of law isn't an illuminating frame for the resulting legal discussion. We don't have to ascend theoretically to Hobbes to talk about this. We can just talk about statutory interpretation and administrative law. Secondly, the administration points to statutes such as 10 U.S.C. 2808, which contain authorities triggered by a declaration under the National Emergencies Act. In this case, the authority to, in the event of the declaration by the President of a national emergency in accordance with the National Emergencies Act that requires use of the armed forces, the Secretary of Defense, without regard to any other provision of law, may undertake military construction projects by spending appropriated but unobligated funds. Now, insofar as we focus on the substantive delegation here, that's 10 U.S.C. 2808, the same logic I mentioned applies. It's an ordinary administrative law question whether the statutes do or do not authorize the presidential action. The National Emergencies Act, for its part, is enacted law. It's an explicit delegation to trigger authorities and other laws by proclamation. Now, that might or might not itself be objectionable on non-delegation grounds as excessively open-ended. If we wanted to have that conversation, we'd have to start with the observation that emergency is a misleading term of art in our law that has perhaps little to do with its colloquial sense. Dozens of statutory emergencies have been declared and ongoing by every administration since 1976. I forget how many the Obama administration declared, but I think it's in the teens. And these emergencies often persist for years. But presidential action under it raises no particular or special concerns about the rule of law. It's just the implementation of a statutory procedure. Well, finally, I mentioned at the outset one caveat to the suggestion that there have been no interesting rule of law issues surrounding executive power since 9/11. The caveat involves some of the episodes in the so-called resistance to the Trump administration. I have in mind particularly the decision by Sally Yates to instruct DOJ personnel not to enforce a presidential order that OLC had determined was lawful. And she did so on the ground that in her view it was not, quote, wise or just, and that she was herself, quote, not convinced of its legality. Of all the colorful dramatis personae of the Trump administration, Yates came the closest to declaring herself a Schmittian decision maker who personally determines when to make an exception to legal rules out of necessity in order to ensure that the state takes no harm, to use the old Roman formulation. It was a failed declaration, of course, but it was an attempt. It's something of a puzzle why theorists interested in discussing the rule of law don't focus on cases like that, which at least supply genuine material. And let me recommend in this regard as a useful citation for those interested in the Yates case, an article that Professor Freed wrote some time ago in a somewhat different context, and the article's title was Impudence. Thank you.
Well, I'm going to take the notion of rule of law and misuse and emergency in a different sense, and not in the wonderfully lawyer-like and quite correct analysis that Adrian has used. It seems to me that President Trump's vociferous and repeated claim that he is acting in an emergency is a case of what I would call civil blasphemy. And I'll get to what I mean by that. I do think the notion of emergency has appeared several important times in our history, and I am reminded of Marx's statement that history repeats itself, first as tragedy and finally as farce. And surely this and almost everything else that President Trump does qualifies as farce. Now, taking the subject seriously, but non-technically, it's quite clear that the issue of sovereignty, which is the subject of the book, and to which I contributed one of the essays, has haunted political philosophy since the time of Aristotle. And here is what Kant said about it. Following really an analysis very similar to Hobbes's, he says, man thus requires a master to break his self-will and force him to obey a universal valid will, that is to say the law, under which everyone can be free. But where is he to find this master? Nowhere else but in the human species. But this master will also be an animal that needs a master. Thus, while man may try as he will, it is hard to see how he can obtain for public justice a supreme authority which would itself be just, whether he seeks this authority in a single person or in a group of many persons, and perhaps in a structured group, as in the separation of powers. This highest authority has to be just in itself and yet also a man. Nothing straight can be constructed from such warped wood as that which man is made of. Nature only requires that we should approximate this idea. And this is what Kant calls the most difficult problem of all. And I think the way we've been talking about it indicates its difficulty. The way that constitutionalists have sought to solve it has been through the notion of legality, but principally through the notion of a separation of powers, such that you don't have a single person whose will must be constrained. You have a complex entity, and the idea is that it's very hard to imagine this complex entity running off the rails as an individual might. Well, that is not necessarily so. And in fact, as Adrian perhaps hinted, we have never thought it is wise or even possible that it in every respect be so. After all, the philosopher closest to our constitutional system and our revolution, Locke, was somebody who spoke a great deal about the need of prerogative, and he was thinking of the king's prerogative, but it would be the prerogative of a single person in times of difficulty and emergency. And in those times, the articulated, careful structure, such as Adrian was illustrating for us, has to be simply put aside. And in Lincoln's phrase, should all the laws but one perish so that that one be respected. And that is one of the most restrained and yet powerful arguments for a kind of Schmittian prerogative. Now, recall when Lincoln invoked it. He invoked it at a time when it was at the beginning of the Civil War, the very beginning. The government was in Washington. The Confederate forces were in Virginia, and the Union forces were in New York and Pennsylvania, and they had to come down to Washington to prevent the whole government being captured by the Confederate forces. And to do that, they had to pass by railroad through Baltimore, where there were many Confederate sympathizers whom Lincoln put in custody. He imprisoned them in Fort McHenry. And there was a writ of habeas corpus issued, and Lincoln's orders were that the commandant of Fort McHenry was simply not to allow the process server in. That was strong medicine. Would anybody say that it was mistaken? Should all the laws but one, etc.? what Lincoln did do is, as soon as possible, he presented what he had done to Congress, which proceeded to ratify it. There was an earlier version where Jefferson, in the so-called Chesapeake or Leopard incident in 1807, spent money to build up the Navy against British depredations, and it was money that had not been authorized. He felt it was absolutely necessary to do it at that point, and at the first occasion, he reported himself to Congress, which ratified what he did. Then, of course, we have the steel seizure example, which is a very dramatic one, and a claim of emergency was made then. And Jackson famously said, in waving that aside, that a very anti-Schmittian remark, he said that the invocation of the commander-in-chief power is fine, but the commander-in-chief is commander-in-chief of the armed forces, not of the nation, its population, and its resources. So there we go. There, throughout our history, we have this notion of an emergency calling forth the determined action, prompt determined action, to save all the laws, lest to violate one law, lest all the other laws go by the books. And in Lincoln's wonderful argument. But it is emergency that invokes this, and it's emergency which Locke foresaw. It is the most, to return to Kant's statement, the most difficult problem of all. I think it was one of the Latin poets came out with the famous quis custodiet ipsos custos. It's simply the question, who will guard these guardians? And that is the infinite regress which Kant attended to. Well, I suggest a resolution. It is in the notion of virtue. Yes, there will be times when you have to expect and accept this kind of extra systemic, extra legal action. But you expect it in a context where the surrounding government and the person invoking this power is a good person, is a person who is devoted to regularity, to law, to justice, to humanity, to all of those things. He is a virtuous person. Now, a virtuous person, in Aristotle's sense, is somebody who works well, virtuously, habitually, because that's the kind of person he always has been, or she always has been, and is now. That is our problem today. We do not have a virtuous person. We have a perfectly deplorable person exercising those powers. So that seems to me the issue. And the notion of civil blasphemy I bring up because the notion of emergency is something that does call forth extraordinary situations, and to invoke it as it has been invoked now whether lawfully or not, but to use that word and that concept with that resonance in a trivial and actually mendacious way is the very heart of evil and the very heart of corruption. That's it. Yeah. Yeah.
So we have about 10 minutes for questions. Raise your hand high and
I am Han Dayuan from Renmin University of China Law School. I'm the professor of constitutional law. We know that there is so many the different challenges, issues between the constitutional principle and the political reality in countries. My question is, what do you think is the most challenging issues between democracy and constitutionalism now? What are the balancing between the democracy issues and the constitutional principle? Thank you.
I don't know if that was for either of us, or so your question is about basic democratic principles and how does that relate to constitutionality of what's going on. And I think, so this is, I think, where I would disagree with Adrian, though I agree with some of what he said. I think the rule of law is a very significant issue today. The fact that what presidents have been doing in the expansion of their authority in times of war, but particularly since we've been in this protracted war against terror since 9/11, may be happening under the auspices of discretion. But if no one is there to challenge that discretion, the exercise of discretion, and in particular, as Charles notes, you have an occupant of the White House who is unethical in his personal decision-making and dishonest in the grounds that he claims for exercising that discretion, then I think you really do start to have a rule of law problem. And democracy, of course, our democracy, doesn't mean that every democracy would have to work this way, but our democracy depends desperately on the idea that we have checks and balances. So what is failing us, I think, what has failed us, but it may start to change, is that the other two branches of government have not been stepping up to the plate and have been abdicating their authority in this expansion of executive authority in times of war, which tends to happen. But the changes in the nature of warfare have made it such that it's no longer an exception, but it becomes the rule.
Well, I would respond by quoting my favorite founding father, Benjamin Franklin, and a famous thing that he said as he was leaving the convention when somebody asked him, what have you done? We have created, what kind of government have you created? A republic, ma'am, if we can keep it. And what determines if we can keep it? It's what Claire refers to as stepping up to the plate. But it depends on an undercurrent of civic virtue in the population, in the politicians, and most of all, in the president. Just think for a minute. We are invoking Lincoln to justify the acts of that mendacious self-indulgent, ignorant man. And these are powers that depend on virtue in their exercise.
Professor, I was just not clear as to your. I was just not clear. For example, you say that not only must the person at the center be virtuous, but also the surrounding government must be virtuous. And that surrounding government then provides checks and balances, which you say are now being abdicated. But the issue is that do you find the surrounding government today, which I would say is the, people like Schiff and the people who are trying to get Trump impeached, do you find them virtuous, or do you find them equally corrupt, trivial, and mendacious and dishonest? Or do you find them virtuous? That's what I'm trying to ask you.
I find them usual, while somebody like Mitch McConnell is unusual in his devotion only to maintaining himself in office. So I don't think Nancy Pelosi is not some paradigm of virtue, but she's an ordinary, decent politician. And maybe that's enough, because what we have is an extraordinarily indecent person in the White House.
Yeah, I might just add to that and say that it has been many, many years since Congress has been willing to examine the exercise of executive authority to any serious degree. So, one irony of the present situation is that Trump may actually be making America great again by smoking Congress out. And one mustn't just focus on Congress. It's been so many years of courts invoking what's called the political question doctrine to say we're not going to second guess the president in times of war, even when the executive branch targeted an American citizen in Yemen, and his father filed for an injunction saying, hey, at least tell me why he's being targeted in a place where we're not at war. Isn't there some due process here? And the court's response was, and this is not the Supreme Court, this is the DC District Court, there might be a due process violation here, but we don't have the authority to consider it. So that's what may start to change. We see activity in the federal district courts that we haven't seen for a while in the Ninth Circuit and elsewhere, and we see new activity on the part of Congress.
Is this on? First, thank you both for coming. This has been... Is this on? First, thank you both for coming. This has been interesting.
But you're not speaking into it.
Does this work?
Yeah.
Wonderful. First, thank you both for coming. This has been interesting and very thought-provoking. My question is for Professor Finkelstein in particular, on the notion of how you're using the term Hobbesian sovereignty. It confuses me a little bit because Hobbes, of course, was a royalist, thought the sovereign could be any system in particular. So it could be our separation of powers, or even more simply Article 5, essentially. How are you using the notion, and how is it not what Professors Vermeulen and Fried have been referring to, which is Schmittian or Machiavellian sovereignty in some form?
Well, I will admit to having a slightly unusual reading of Hobbes, but I really think it's justified by the text. I think there's a kind of anachronistic reading of Hobbes as Schmitt, kind of back, or as Machiavelli, which is not warranted by his texts. He was, first of all, interestingly, very concerned about virtue. And so I think Charles might find him possibly as interesting as Locke in some regards. He was, I would say, more focused on virtue than Locke was. But second of all, he really did have implicit in what he talked about the conception that in a state of nature, when we are not in civil society, we are at liberty to do anything. And the only reason why we would subject ourselves to a sovereign, right, we have no natural allegiance to a sovereign, is that we can expect to do better that way. And that, to me, puts the concept of popular sovereignty front and center, because the sovereign holds no authority unless it is by authorization of the people. And that's why I think of him as the sort of proto-democratic theorist, despite the allegiance with monarchical systems of government and his defense of the king.
Before we break up, as I gather we have to, let me just say that this book is quite striking by the depth and subtlety in which it goes into these things as a matter of textual analysis of Hobbes and as a matter of the political philosophy of sovereignty, and an aspect of sovereignty which we haven't touched on, which the book refers to as vertical sovereignty, and that is the sovereignty of a nation vis-a-vis other nations, which is quite a different matter. That in fact, you can have one concept of sovereignty which is rather intricate and perhaps bounded, but don't allow other people, other sovereigns, to trespass on it. So, and that has been as much an issue of sovereignty as has been what you might call vertical sovereignty, which is what we've been talking about. And these are all considered with considerable subtlety and learning. That's my plug for the bookstore and for the book. Including an essay by Claire. And me.
Unfortunately, time is out and we have to depart, but on behalf of the library, Professor Finkelstein, Professor Fried,
Thank you.